Okay, good morning, everybody, and welcome to our Wednesday morning seminar. Today we are joined by John Sharp, consultant solicitor at Fletcher Day, and he's going to be doing his construction and case law roundup. Construction and insurance case law roundup, the second in a series that he's currently running. As always, if you have any questions for John, please don't hesitate to use the Q&A or chat facility in the bottom toolbar. Alternatively, if there's something as we're going through that you'd like to know but don't want to ask in an open forum, you can email him on john.sharp@fletcherday.co.uk. You will see his details on the screen shortly. So without any further ado, John, I will hand over to you.
Thank you very much, Julie. Good morning, everyone. I do apologise for my slightly unsightly appearance this morning in my right eye. I went clay pigeon shooting at the weekend and unfortunately got something stuck in it, and it's taking a while to go away, so apologies for that. I'm going to look at 3 or 4 cases today in a little bit more detail because I think they're reasonably important. So without further ado, yes, that's me. All my details are on the website. Been an interesting decision as regards to insolvency. Let me just give you a little bit of background to this most recent decision. In a case called Brescoe and Lonsdale, the Supreme Court ruled that insolvent parties could refer a dispute to adjudication and obtain a decision, seek to enforce it against a counterparty, but obviously there will be some hurdles for the insolvent company to overcome. So against that background, this case, the dispute between John Doyle and Erith was heard at first instance by Mr. Justice Fraser in the TCC. John Doyle and Erith, they'd been in dispute regarding a final account payment on a subcontract relating to the works carried out at the Olympic Park as long ago as 2012. John Doyle had unfortunately become insolvent before the end of the project, leading a subcontractor, Erith, to complete and finish the works. John Doyle claimed approximately £4 million as owing on the final account. Erith claimed that John Doyle had been overpaid already by about £3 million. A very lengthy adjudication took place over some 5 months, I think it was, and the adjudicator eventually awarded John Doyle £, just under £1 million, plus interest and applicable VAT. John Doyle then sold their claim to a litigation funder. And that litigation funder effectively brought the proceedings to try and enforce the award. Now, at first instance, Fraser J stressed again that at the enforcement stage, barriers remain to enforcement of an adjudicator's decision by insolvent parties, and the court will consider a number of factors in deciding whether to allow enforcement or not. Those matters include whether the adjudication has dealt with all of the outstanding matters, so all of the outstanding matters between the parties, whether under the construction contract or not, and whether appropriate security is put forward to ensure the paying party can recover the sums paid and their legal costs in the event of a subsequent challenge to the adjudicator's decision. Security is something that comes up on a number of occasions in English law. For example, if you are a foreign company seeking to for example, enforce a decision of a foreign court against an English company, the English company can apply for what's called security for costs. So it can say, well, that's all very well, court, that's fine. I appreciate I've been sued in relation to this foreign judgment, but what if I am successful? Will I be able to recover the costs that I'm going to necessarily expend in defending this claim? I don't know, and I shouldn't be put to the expense of having to go to the foreign company in a foreign jurisdiction to try and recover my costs. You, court, should make an award for security for costs so that the company pays into court or provides a bank guarantee or something that at least covers my costs. So it's a common principle of English law. Going back to this case then, there was an appeal because the security put forward by John Doyle by way of an after-the-event insurance policy was very, very flimsy. And Coulson LJ found that the burden on an insolvent claimant seeking to enforce an adjudicator's decision was such that any undertakings or security being offered by a claim company in liquidation needs to be clear, evidenced, and unequivocal. Now, in that particular case, in the John Doyle case, that test had not been met, and therefore the court would not allow enforcement of the award. However, I think you can understand from that that it's not in all circumstances that the courts won't allow an insolvent company to enforce an adjudicator's award. If they provide good security, then there is no reason why they can't. It was just in this case that the security offered was not sufficient. In addition, was held that an insolvent company will not be entitled to enforcement of an adjudication award by way of summary judgment where there is a potential set-off by way of cross-claim which has not been finally determined. Okay. Now, I thought I would just mention, whilst on the subject of insolvency, the third-party right is a useful tool. Excuse me, ladies and gentlemen. The Third-Party Rights Against Insurers Act hasn't been used that much, but nevertheless, it's there. What it says is that, say you are a main contractor and you've hired a subcontractor. You have a contract and that subcontractor goes bust. And it transpires that not only has it gone bust, but the work that it carried out on your construction contract for which you hired the subcontractor has been faulty. Bad workmanship, let's just put it that way. Now, if the subcontractor had remained solvent, it could have claimed on its insurance policy. Said, oops, I've made a mistake here, guys, bad workmanship or whatever, I can claim on my insurance policy. But it can't now because it's gone bust. But what the Third-Party Rights Against Insurers Act says is that you, as the main contractor, can step into the shoes of the subcontractor and claim on the insurance policy. Now, it hasn't, as far as I can see, it hasn't yet been used, but I'm surprised about it. But I can't find a case where it's actually been used as yet, but it's nevertheless there. So probably something worth bearing in mind, I would have thought. A quick look now at final statements. This is the case of CC Construction and Minisione. I think I've said that right with my appalling Italian accent there. I'll just give you the background to the case. Mr. Minisione, the employer, employed CC Construction Limited for the design and construction of a new house under JCT Design and Build Contract 2011 edition. The contract sum was £3 million. Work started in April 2016 and practical completion took place in November 2019. The contractor issued its final statement of around £480,000 and the employer disputed this sum. Consequently, the dispute went to adjudication and then legal proceedings. The dispute centred on the sums due under the contract, whether the employer was entitled to liquidated damages and when those payments were to be made. This case centred on the JCT D&B contract 2011. However, the provisions are largely similar to those in the 2016. Within 3 months after practical completion, the contractor submits its final statement. If the employer disputes the sum in the final statement, it must give notice prior to the due date. If the employer does not provide notice before the due date, the final sum becomes conclusive. We all know that. The due date is 1 month after the latest of the end of the rectification period, the date stated in the notice of making good, or the date of submission of the final statement. No later than 5 days after the due date, the contractor must then give a final payment notice stating what it believes is due. If the employer believes the sum due is less, the employer must then issue a pay less notice no later than 5 days before the final date for payment, which is 14 days after the due date. The employer will either pay the amount stated in the pay less notice, or if no pay less notice is issued, the sum stated in the final payment notice before the final date for payment. In the 2011 edition, the final date for payment is 28 days after the due date. The key issues disputed in the adjudication were whether the final statement was conclusive, if the dispute had crystallised, and if the employer had a right to set off monies otherwise owed to the contractor due to the liquidated and asserted damage. Right, well, in this case, the court has now provided some much needed clarity on when final statements become conclusive, when disputes crystallise for the purposes of adjudication, and when adjudicators have jurisdiction to consider a counsel set-off claim in the case of CC in this case. Firstly, when responding to a final statement, the employer must be as clear as possible that they are disputing the sum in the final statement to ensure that they are not required to pay the final sum statement. So don't be ambiguous, you need to be absolutely clear when you're responding to a final statement. Secondly, the court is now said that it is going to be very rare that it will decide that a dispute has not crystallized. Thirdly, a responding party can raise any defence it likes, it considers properly arguable to defend the claim, and any failure by the adjudicator to take into account those arguments may invalidate his decision. The court went on to say that even if the arguments raised by the responding party are just wrong in law, so they're just, for want of a better description, fairly rubbish, the adjudicator still has to deal with them. He can't just go, oh, well, that is complete rubbish, I'm not even going to mention it. The adjudicator still has to take into account those arguments when he makes his decision. I thought we'd have a quick look at trees for reasons that I will make clear. Well, hopefully make clear anyway. This was an interesting case about falling trees. In August 2016, when visiting Lyme Park in Cheshire, which is managed by the National Trust, the claimant suffered life-changing injuries when a branch fell on her from a horse chestnut tree. Most of the facts in the case were actually agreed slightly unusually. It was agreed that the tree had a common disease, which was called horse bleeding canker, which leads to decay, and the failure of the branch was an indirect result of the disease. Now, the National Trust argued that it had discharged its duty of care to visitors by operating a comprehensive and multifaceted tree safety system. So at its heart was a formal system of inspection set out in the National Tree Safety Management Policy, which was devised and influenced by National Tree Safety Group, and in particular its 2011 report, Common Sense Risk Management of Trees, which set out the frequency and nature of inspections by its team of trained park rangers, depending on the location of the tree. The policy required the inspector to identify obvious risks and defects by carrying out a walk-by inspection. There was zoning within the park, so zones were inspected intermittently. Further, the park was always closed in high winds, very sensible. And there was then a system after a major storm of going round and inspecting the public park again to make sure that there were no trees that had fallen, had been damaged, etc. Now, it was agreed by both parties' experts that an inspection of the tree every 3 years based on a medium zone inspection was reasonable, and that a walk-by inspection of every tree looking for obvious defects was also reasonable. There was therefore no challenge to the system of inspection, the training of the defendant's inspectors. What the claimant said was that the policy had not been properly implemented, and that when that particular tree had been inspected in December 2014, that wasn't good enough. However, the court did find that the tree inspection system was properly carried out. But what it did do, and this is probably the important thing, is that it looked again at the duty of care that is owed to visitors to any site. It doesn't matter whether it's a park, it could be, and probably most relevant for our present purposes, is to a construction site. So what is the standard of care? Well, in that particular case, the standard of care is that of an ordinarily skilled tree inspector. So by analogy, if you have visitors to a construction site for which you, of course, are responsible for the safety of those visitors, then the standard is of an ordinarily skilled site manager. Now, by that, so say I'm going to visit a site to take a short witness. Yeah. It does not mean that when I visit the site that I have to have a 3-hour safety briefing from the site manager before I can venture onto the site. That's not what the courts are saying. That's too hard. But nor is it the site manager points me in the general direction of the site manager's office, of his office, and says, my office is over there, you're sitting in there, mind the hole as you walk over there. It's not that either. What it is the site manager ringing me up the day before saying, have you got a hard hat, high-vis jacket and proper shoes, but because you need them? I say no. He says, fine, I'll get you a hard hat and high-vis jacket. When you get to the site, I'll meet you in the car park. He meets me in the car park. He then hands me over to one of the younger members of the site team, who walks me across to the site manager's office. Yeah. And then he says to me, when you finish in the site manager's office, ring me and I will send one of my team to escort you back to your car park. That is what's expected. It's the ordinarily skilled site manager. Now, obviously, the larger the site, etc., the more probably is going to be expected to be done in terms of health and safety. But a normal building site, that's what's expected. An ordinarily skilled site manager, how does he handle and deal with visitors? More on the building safety bill, I'm afraid. I don't think as yet it's been enacted, but it's not going to be long before it's in place, I'm afraid. And again, it's not necessarily good news for everyone here. The new Act's going to impose a duty on those who manage or are responsible for high-rise residential buildings, so those over 8 meters or 7 stories, to take all reasonable steps to ensure the building is safe. If the HSE then come and direct, that person must prepare a safety case to produce a safety case report. So, and in that report, you have got to show how you are keeping the high-rise buildings safe. So what are you doing on a day-to-day basis? How measures are in place to prevent and limit the consequences of a major accident? You must demonstrate that these are both sufficient and effective, and that you have a robust approach to ongoing management of the building to make sure that those measures remain effective. Okay? So as I said, this hasn't yet come into force. But what the HSE has done in order to prepare parties for the proposed new regulations, the HSE has published details of the safety case principles, and the HSE is encouraging those responsible for high-rise residential buildings to consider these principles when preparing for the new regime. So you can go onto the HSE's website and look at what is going to be expected of you. But as I said, this is the second time I've mentioned the building safety bill in talks recently. It is going to be important. It do need to be prepared for it. And in particular, the guidance set out by the HSE is going to be particularly relevant when it comes to what you need to do if you are responsible for or managing a high-rise residential building. Lastly, I thought we'd just have a quick look at collateral warranties and the Construction Act. The question always is whether a collateral warranty is a construction contract within the meaning of the Construction Act. And that was looked at in the case of Topan Holdings and Simply Construct. To give you the background, certain fire safety defects were discovered in a care home after practical completion. The contractor, who are the Simply Construct people, were asked to rectify those defects. That's the process, but when they failed to do so, the freeholder, Topan, and the tenant, Abbey, employed a separate contractor to carry out the remediation work. So a typical normal situation. A collateral warranty is provided by the contractor to Abbey, but only after Topan had issued proceedings for specific performance for delivery of the collateral warranty, as was required under the building contract. Under the warranty, the contractor warranted that the contractor has performed and will continue to perform diligently its obligations under the building contract. Topan and Abbey then brought parallel adjudication proceedings against the contractor to recover their respective losses following the remediation work, which were awarded in 2 separate awards. At the enforcement hearing of the adjudicator's decision, the central issue in the Abbey claim was whether the collateral warranty constituted a construction contract. If it was not a construction contract, as the contractor argued, the adjudication has no jurisdiction to make an award in Abbey's favour, and the decision would be unenforceable. Now, in that particular case, it was held that a collateral warranty executed 4 years after completion of the original works was not a construction contract, but instead operated as a warranty in respect of the past performance of the building contract. Let me quote you from the judge, Justice Aikenhead, said, "A very strong pointer will be whether or not the relevant contractor is undertaking to the beneficiary of the warranty to carry out such operations. A pointer against that may be that all the works are completed and that the contractor is simply warranting a past state of affairs as reaching a certain level, quality, or standard." So it's going to turn on the facts probably in each case. However, please do note, though, that whether or not a collateral warranty is deemed to be a construction contract, it will not impact a party's right to commence court proceedings for breach of contract. Just to conclude, I thought, again, I would just touch on business insurance. I know that many people have now made claims or are thinking about making claims, or may have gone to the Financial Ombudsman based on the Supreme Court's decision, which most people regard as being reasonably favourable. I just thought I would say that I'm doing 2 or 3 of these at the moment in terms of business interruption claims. And I would just remind you that insurers have certainly not given up. They are very much now relying on the "you weren't forced to close" argument. I think many of you who may have seen some of my other talks will know that the courts drew a distinction between those businesses that were forced to close. So restaurants, cinemas, nightclubs, they were forced to shut. If they had stayed open, the police would have come and shut them down. Yeah, they had to shut. They were mandated to shut. Contrast that position with offices, warehouses, factories, etc. What the House of Lords said is, yes, of course, you were probably well advised to shut to protect your workforce, etc., 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 but you didn't have to. There was no big stick being wielded over your head by the government forcing you to shut. You could have stayed open. Indeed, I suppose, if I had wanted to go to the office in the middle of lockdown, then I could have done. There would have been nothing to stop me. I wouldn't have been arrested. I would have gone to my office, I'd have sat there and I'd have worked, and my office would have been open. And that is what's going to cause the difficulties going forward. Now, of course, the arguments have to be, we had to shut because we would have endangered our workforce, etc. Those arguments haven't yet got before the court, but I think at some stage they will. On that note, I shall leave you and hand you all back to Julie, who I'm having a little bit of difficulty hearing this morning. So I will say farewell to you all, and I hope you've enjoyed the talk. Any questions, as Julie has said, please don't hesitate to email me, and I'll do my very best to answer them. Thanks, Julie. Thank you, everyone.
Thank you, John. Yes, having difficulty hearing me is often a good thing. I'm sure you would agree. Right, there don't appear to be any questions, so as John has reiterated, please feel free to email him, john.sharp@fletcherday.co.uk, if you have any questions on this topic or insurance construction generally. He's always happy to help. We are next online this evening with Richard Silver with Problems on Construction Projects Part 1. If you would like a place or to be able to log in for this, please email seminars@fletcherday.co.uk and I will get that organised for you. Without any further ado, I'll say goodbye to everyone and I hope you all have a great Wednesday morning. Take care.